Selective service is basically the military draft. You have to register as a male between the ages of 18 and 26 for the draft in case it is ever implemented in the United States again, which can occur during any wartime conflict. The last time the U.S. had a military draft was during the Vietnam conflict that began in the 1960s. When you obtain a green card, you sign on the last page of the adjustment of status form that you understand you have the obligation, if you are male between these ages, to register for selective service. There are limited exceptions for those who do not have to apply for selective service. But even if you are here illegally, you still have to register. Men who are in the United States on student visas or visitors visas who are still in valid status are not required to register. But legal permanent residents, the undocumented, and even refugees, if they have taken up residence in the United States before their 26th birthday, must register. If you're not sure if you have to register, go to www.sss.gov and there's a chart when you can find your visa category and determine whether or not you have to register. Where selective service registration trips people up is when they apply for naturalization or the application process to become a U.S. citizen. You can do this after you've had a green card for a minimum of 3 years if you're married to and living with a U.S. citizen, or 5 years if you got your green card any other way, such as through employment or asylum. You can also apply at the 3-year mark if you obtained your green card through the Violence Against Women Act. Failure to register for selective service during this either 3-year or 5-year good moral character time period is cause to deny a naturalization application. It shows lack of good moral character to immigration. Many people just forget or don't realize that they have this requirement. The difficulty is that on this adjustment form, the I-45 that you signed when applying for a green card, it lists on the last page this requirement. This is your notice that you have to register even after you become a permanent resident. But still, if you did not realize this requirement or unintentionally did not register because you didn't know about it, this may be excused if CIS finds your testimony credible. CIS cannot deny your naturalization case if it was more than 3 years past that cutoff age for registering for selective service if you're applying for citizenship based on marriage to a U.S. citizen, because, again, they're only looking at the last 3 years for moral character in that kind of situation. So, for instance, if you are now 29 years old, fail to register, you can no longer register because you're too old, and you did not knowingly or intentionally avoid the requirement of registering, CIS cannot deny your naturalization case on that basis. Similarly, if you received your green card through employment or are now divorced from your U.S. citizen spouse, your moral character period is 5 years since you obtained your green card. If it has been more than 5 years since you had to register for selective service, then your failure to register, if you can prove it wasn't intentional, will be forgiven and cannot be held against you as proof of lack of good moral character to bar your naturalization case. The reason I'm having a video about this is there has been a recent trend in the district offices with naturalization officers who are looking very closely at the selective service registration. You usually have to print out proof that you've registered and bring this to the interview. If you don't have this proof, you will have to explain in detail why you did not have to register, and if you did have to, why you did not do so. Again, it's advisable before going into any appearance before immigration to consult with an immigration attorney, and further to have an immigration attorney with you at that time, because even naturalization officers may not understand the 3 or 5 year good moral character period as it applies to selective service in some circumstances. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.